Hi, my name is Barry Doyle. I'm a lawyer in Chicago. Today we're going to be talking about what happens when you have a pre-existing condition and you suffer an on-the-job injury. It's actually a pretty surprising answer. When I was promoting this post, somebody had said that you're screwed. And the actual answer is you're not. And that really is something that would surprise a lot of people about what happens if you have a pre-existing condition. It's important information for anyone who drives a truck to have this. Truck driving is a tough gig, and a lot of guys have bad knees, bad backs, bad shoulders, what have you. And, as soon as you get into an accident, the first thing the company is going to be doing is looking at, was this a pre-existing condition? Did they have degenerative changes? And trying to find a way to get out of paying you the workers' comp benefits that you're actually due. Hit like, hit share. This is good information for anyone who drives a truck. Hitting like, hitting share puts it out in your network. If there are other truck drivers who need this information, this helps them get that. So let's dig in. Let's get started. What happens if you have a pre-existing condition and you get involved in a work-related accident where you get hurt? And a lot of people think that that's just a get-out-of-jail-free card for the company, and it's not. The law in Illinois is, there are a couple of points that really make the law relatively favorable in Illinois for truck drivers who get hurt on the job. The first point is that the company takes the driver as they find him. So basically, if you have all kinds of degenerative arthritic changes in your back or in your knees or your shoulder, whatever it is that gets hurt, the company has to deal with you the way that they found you. In other words, you had that to begin with. You worked with them with it, and now they got to deal with you after you've been hurt with it. The second part of it is actually an important one, and that's that the standard for causation in Illinois is that the work-related accident was a cause, and I use the finger quotes very deliberately because a cause is very different from the cause or the primary cause or the main cause. It just has to be a cause, which means it can be one of several causes. It can be not even the most important one of the causes. And just showing a cause with the finger quotes is all that has to be shown to establish that you're entitled to workers' compensation benefits that you're talking about. Let's take a real common kind of scenario. You're out and there's a load that needs to be retarped, or something is being unloaded or it's shifted, and you have what my old bosses used to call a eureka moment, where you feel a pop in your back and you know things aren't good. And you find your way to an emergency room and they take an x-ray of your low back. One thing leads to another, and you're getting some significant medical care, whether it's physical therapy, you're getting injections in your back, what have you. Eventually, the claim gets going, and the company, whether it's the company itself or their insurance company, gets a hold of your medical records, and they look at the x-ray that was taken in the emergency room of your low back and see that you have degenerative changes in your low back. And the next thing there's going to be some discussion about, is this really a work-related condition? Is this something that you've just been living with, and finally just one day decided that you had just enough, and you're going to take advantage of that low back ache that you've always had to get free workers' compensation benefits, to get free medical care, and really milk the system, game the system. That's fraud if you do that, and it's something like literally you can end up going to jail for. But the company and their insurance company is always going to have a close eye out when you have a pre-existing condition like that. But the fact of the matter is that lots of people have degenerative changes, arthritic changes, whether it's in their back or their knee or their neck or their shoulder, and they're functioning just fine. And what counts is whether or not the symptoms that you're having, which are requiring all the medical care, which are keeping you off of work, were caused in part, remember, a cause, were caused in part by your work-related accident. If that's the case, you're entitled to get your benefits. You're entitled to get your 2/3 your average weekly wage while you're off. You're entitled to get your medical expenses paid, and you are entitled to get a settlement based on the permanency that's associated with your injury. The fact that you have these changes doesn't keep you from getting the benefits you want, but it's something where the insurance company is certainly going to be looking at your case and your claim a lot more closely, and looking for grounds to either deny or limit the claim. So how do you go, when you have some type of degenerative change, whether it's an arthritic change in your low back, what have you, it's a situation where you really ought to be getting a well-qualified workers' compensation lawyer to help you, because the quality of the proof that you put on makes all the difference in the kind of result that you get. So, let's go back to our example where you hurt your back tarping a load on your trailer. How do you prove that you were doing just fine before that? Part of the proof might be that you had a solid work record, that you worked a consistent schedule for weeks and months leading up to that. Proof of that might be that you had visits to your primary care doctor, and there was a physical done and there was nothing found with regard to your back, that you never made complaints to a doctor regarding your back. Perhaps you're relatively new to the company and they performed a more extensive physical on you than a DOT physical. All that kind of proof is out there that shows that you were doing just fine before that. And then, even if you had these degenerative problems beforehand, that's the proof that the work-related accident was a cause of whatever problems is that you had after that. Now let's take a look at a slightly different situation, and that's where you did have some problems, but they were relatively minor. Let's just say that you had some low backache, and you would see a chiropractor every once in a while. You get an adjustment, and then go back to work and be just fine. That work record obviously is going to be important because it's showing that whatever problems you had, it didn't keep you from working. But then, what you also want to look at is, what was your doctor saying about you before you had this accident? If the doctor's, recording that you have relatively mild levels of pain, and then after the accident you're having significantly more pain, that's something that makes a big difference in showing the proof of how your pre-existing condition was aggravated by the work-related accident. So it really comes down to a question of proof, and try and be able to sequence this proof in a proper kind of way is going to make all the difference in the world in the kind of benefits that you get following this accident. So having an aggravation of a pre-existing condition is something that's compensable. Having a degenerative condition which was aggravated and made symptomatic, those are all perfectly valid workers' compensation claims. So the idea that having a degenerative condition, having a pre-existing condition is a get-out-of-jail-free card for the company and their insurance company, it's just false. And if somebody is trying to tell you that, especially from the company or their insurance company, they're selling you down the river. It is a situation where it's a more complex case. It is a situation where the quality of the proof that you put on makes all the difference in terms of how the case ultimately turns out. So yes, it is the kind of case where I would always recommend to you that you get a well-qualified workers' compensation lawyer to help you with it. The bottom line on it is, if you have a pre-existing condition, you're not screwed. You do have a valid case even if you have a pre-existing condition that's been aggravated. All we have to do is show that the work accident was a cause of problems that you have, and it's a compensable injury. So I hope this has been helpful. Hit like, hit share if you think that this has been valuable. Get this information out into your network of other drivers, because certainly somebody else can use this kind of information because they're having this kind of situation come up in their own life. You can certainly visit our website, rightsofinjuredtruckers.com, to get more information. You can also call our office at area code 312-263-1080. The call is free. There's no obligation to hire us. We're happy to talk to anybody about what their rights are after a workplace accident. Be safe. Take care. Bye-bye.